What kind of key proactive steps that business owners can do to ring-fence their personal estates from corporate exposure? Is it through a shareholder agreements? Or?
I guess the ring fencing comes at many levels. Your shareholders agreement will demarcate responsibilities, demarcate between shareholders the affairs of the company should be run. But I don't think that goes very far to help, in your question, ring fence personal assets. I think the kind of, I don't know why you call it ring fencing, but at least the kind of mitigatory steps you can take, for example, is if you, flowing from what you have asked me earlier on directors' liabilities and directors' duties and how that can open one to personal exposure, then perhaps the company can consider, D&O liability insurance for the directors. That goes some way to mitigate a little bit of that kind of exposure. There are other kind of, we should probably be more familiar than me, financial products out there that can also help mitigate a little bit of this kind of risk that the director would be taking, because that would be one of the main areas of personal liability exposure that one would be faced in a corporate structure. So those are things that can be considered. If you talk about ring fencing personal assets, I don't think your will be much of a use as well, because if as director you are found liable for certain wrongdoing, no matter how you ring fence it in your will, I don't see how much protection that can give you though.
If a trust set up, will you be able to ring fence their personal estate?
Trust perhaps, but it depends on what kind of liability. So liability can come in many forms, right? It can be simple negligence, it can be just run-of-the-mill regulatory, it could be something as serious as tax avoidance. And so depending on what kind of liability you're talking about, will a trust arrangement 100% guarantee you protection in every kind of situation? I don't think so. But what I typically tell clients is better than nothing, right? Right. The more you can buffer it, the better. But don't assume that it's 100% guaranteed that you can get off scot-free.
Okay. So on the financial part of things, how does ACRA and IRAS view the liabilities of a deceased director?
I'm not sure what they would think, but I don't work for the regulatory bodies, but I guess, again, it depends on what kind of liabilities.
Financial
I'm not so sure, right? So, ACRA side, I mean, because we do quite a wide breadth, so some of the things that we note in terms of and you're mentioning directors that are still alive, right?
No, in the passed on and has.
So if they are still alive, I have experience of some of the regulatory enforcement actions that they will take. If that director has already passed on, typically I guess it will be a situation where I guess other directors will then therefore have to take on responsibility. But again, it also depends on the kind of liability you're talking about. So if you're talking about IRAS, I mean, the only one I can imagine is maybe tax avoidance, right? And if it's tax avoidance and there are certain penalties or certain civil claims that come with it, then I guess the estate will still be liable. But again, it depends on what kind of liabilities you're talking about though.